Good morning, everyone, and thank you for joining us today. I'm Letitia Stevenson, a child support specialist for Riverside County Department of Child Support Services. We are so excited you were able to join us for this year's employer workshop. We work around the clock during the year to focus on ways to help you better understand child support and the important documents that is needed for your employees. I want to take this time and thank all employers, customers, and everyone who joined us from around the different counties. This would not be possible without you. We have collaborated with San Bernardino, Kern, the state, and Imperial to make this all happen for you. If you have any questions during the presentation, please feel free to put them in the chat, and we will answer them accordingly at the end of the presentation. First up, we have Barbara Wall-Ocean with the introduction to child support.
Thank you, Letitia, and welcome everybody. Again, as they said, my name is Barbara Wall-Ocean from San Bernardino County Child Support. And if you just bear with me for a moment, I'm going to share my screen so we can get this going. So just bear with me for one moment. Okay, there we are. Again, I'm just going to give you a little introduction to child support and why and how we do what we do. Let me tell you a little bit about the structure of the program. We have the Federal Office of Child Support, which is all of the United States. We have the local state child support agencies, which in our case is the California Child Support Services. And then we have 48 local child support agencies in the state of California to assist all the needs. Next slide. Oops. Sorry about that. Let me tell you a little bit about how we open our cases. Now, we will receive a service referral from the Department of Social Services for dependents who are receiving CalWORKs, that is, cash aid, or the dependents are in foster care, or we can receive an application for services from the custodial or non-custodial parent, or we may even receive a referral from another child support agency. Now, some common misconceptions are that if you have any services from the Department of Welfare Services, that a case is automatically open. That is not true. If you're receiving food stamps or Medi-Cal only, then a case is not automatically open. That is to say, you can open a case or they can open a case, but it's not automatically. Either party can open a case. That could be the non-custodial parent or the custodial party. We also enforce for other states if the non-custodial parent resides in our state, or we may request the assistance of another state if the non-custodial parent resides there. The reason that we do that is being that the state where the non-custodial parent resides will have better access to more enforcement remedies. We also have reciprocity with many other countries, but not all. Additionally, some countries may not have reciprocity with the United States, but they do have an agreement with the state of California. An example of such countries is Bermuda, Quebec, Fiji, Mexico, New Zealand, and the Republic of South Africa. We also have reciprocity with the tribal court of the Yurok tribe. Next slide. Now, what are some of the services that we offer for the local child support agency? We offer locate services. We can help to establish paternity if applicable, establish a court order, or if there is already an existing court order, we will enforce that. That is child, medical, spousal support, private party / dissolution, which is basically divorce orders. We can modify child support court orders, and we can enforce and collect on arrears only cases. Now, services that we do not offer anything dealing with divorce, custody of the minors, visitation, restraining orders, and we do not establish spousal support orders. We will enforce spousal support orders, but only in conjunction with current child support. So when the minor children have emancipated, we will then no longer enforce any spousal support orders. Next slide. The withholding priority is current child and family support, medical support. Now, the medical support can be premiums or any other medical support, whatever, depending upon what is ordered on the court order. Current spousal support, child family support arrears, and spousal support arrears. Realizing in this order of priority that current support always takes priority over other deductions. Next slide. Now, how does child support work? We can open the case, we can locate the parents, we can file a summons and complaint. What that is that what we are asking for. We can establish legal parentage, we can create a stipulated agreement. And what is mean by that is that both parties agree to the amount that we are asking, then we can do a stipulation. If not, then we need to go to court. We can file the support order. We can be in charge of making or receiving payments. We can enforce the order. We can modify the order if needed. And we can close the case if, for whatever reason, the non-aided party decides they no longer want the case open, then they have the right to close it. If the case has been paid in full and there are no arrears owing, then we can close that case out also. Next slide. Confidentiality is very big. Everything that we do is confidential, and we can only discuss the case with you as it relates to the employer's ability to process the order and to enforce the order. We want to work with you because we truly appreciate all of the hard work that you all do. But again, we still have that confidentiality thing. Next slide. Now, there are two different types of cases, and what's the difference? From the child support agency or the local child support agency, cases managed by the local child support agency, that is, say, for the county of San Bernardino, the county of Kern, therefore, things like that. These are called 4D cases, referring to Title 4D of the Federal Social Security Act, which is the law that created the child support agencies. These income withholding orders are issued by the child support agency and do not require a judge's signature. We also have private cases. If the case is not being managed through a child support agency, the family court will issue the income withholding order. This is called a non-4D case. You, the employer, will be served with the documentation by a private party, and that could be either the person who's receiving the support or that person's representatives. Next slide. And what is your role as an employer? I mean, I know you have so many roles, but this is just a little bit further of what we need from you. The employer's responsibility is the same in both the 4D and the non-4D cases, except on one point. Non-4D orders do not originate within the child support system. They go through the California State Disbursement Unit, which processes all child support agencies. And be that as it may, we need additional information to assure the payment is processed accurately. That could be information such as not only the name and social security number, the date of withholding, the amount of payment, court order number, case number, whatever information that you have that will make sure that the non-custodial parent is given the proper credit. Now, employers may also be served by an income withholding order by a California local child support agency, by another state's child support agency, or by a private party. So either way you get an income withholding order, it's very important that you follow along with whatever it is requesting from you. Next slide. Now, how can you help the community by complying with the child support withholding? As I said before, we appreciate you so much, but I just want to let you know a little bit about why we do this. Now, by deducting for child and medical support obligations, realize that more than 70% of the child support collections sent to families come from income withholding orders. By enrolling children in employer-sponsored health insurance, if available and of reasonable cost for the non-custodial parent. Now, what is reasonable cost? That will be discussed a little later in the presentation. We can save taxpayers' dollars. Child support collections reimburse public assistance spending and reduce government spending by increasing child support collections for families who would otherwise be forced to seek public assistance. Now, we can prevent and reduce fraud. State agencies use new higher employment information to reduce overpayments in areas of public assistance, unemployment insurance, disability insurance, and workers' compensation benefits. By promoting a stable and reliable workforce, employees whose children are provided consistent support will face less stress and be better able to focus on their jobs. By encouraging a future skilled workforce, providing financial stability through child support contributes to the education and training of a new generation of workers. And last, but certainly not least, the child support collections will improve the financial stability for families. Next slide. This is a little thing that we have that shows statistics that I spoke to you about earlier. Again, as an employer, you are one of our closest partners, and we have to work together for this. And that goes both ways. But again, more than 70% of all child support collections are through payroll deductions, which means more money for the family. Next slide. This collaboration has been brought to you by 4 different counties. First, we have Kern County, which has an office in Bakersfield and Ridgecrest, and they also have Kern County Child Support Services.com. Then we have Riverside County, which has offices in Blythe, Indio, Riverside, and they are riversidechildsupport.com. Next slide. San Bernardino County, we have offices in Loma Linda, Ontario, and Victorville, and our email is sbcounty.gov/DCSS. Actually, that's our website. Also in Imperial County, they have an office in El Centro, and their website is css.imperialcounty.org. Feel free to place any questions that you may have in the chat, and we will answer them as we go. And I thank you so very much for your time.
Thank you, Barbara, for all that good information on introduction to child support. Now we will have Herbad Rashidi with IWO requirements. Herbad?
Good morning. We're going to go over income withholding orders, also called wage assignments, and talk about what they entail, what they are, and what we need to do to comply with them, and go through them briefly and see what we need to do to get more familiar with them. Income withholding order can come in one of 3 ways generally. So one of the ways you may see them is just coming from the Department of Child Support Services. When they come from the Department of Child Support Services, generally they will not have a judge's signature on them. Under the Code of Civil Procedure, we're authorized to issue them administratively, and that's under Code of Civil Procedure 706-030. 706.030. The local child support agencies are authorized to issue those administratively. The other ways you might see them coming into your office is by private parties, and those will need to have a judge's signature on them. And they're generally issued ex parte, and you would basically administer them the same way. And the other way you may see them is coming from out of state. Throughout your materials, at the bottom of them, you might see some citations to code sections that start with the number 500 point and then some other number. Those are references to the Uniform Interstate Family Support Act. I provided those numbers for you in the event you need to look up the UIFSA, that's the short acronym for Uniform Interstate Family Support Act, in case you want to look up the law for yourself. But generally speaking, as your slide number 18 shows, the income withholding order is a court order or administrative order served on an employer that requires them to withhold a specified amount of an employee's wages for payment of child support and medical support. It may also be referred to as a wage assignment, garnishment order, or an income withholding or support order. Like I said, they may also come from the local child support agency, by private party, or by another state's child support agency. Income withholding is the most effective method of child support collection. In California, wage withholding accounts for more than 65% of child support collected. And for that reason, we're very appreciative of our partners in the business community for helping us with these collections. That's generally what it looks like. The other materials that was sent to you, I believe as a packet, will have a larger copy of it for you. The document on the left side of your screen, PowerPoint number 18, slide number 18 will have a front cover of it on there for you. It will tell you how much you need to garnish the amount for child support. If there is a spousal support order, amount for spousal support, and how much you need to take out for any arrears, if there are any arrears owing. And then at the bottom of that, at the bottom of the page, it will also delineate for you how to take it out, and that's dependent on how your employee gets paid. If they get paid weekly, we ask you to take it out weekly. If they get paid bi-weekly, it's bi-weekly. So it just breaks it down for you right there on the wage assignment. We have to get an income withholding order with every case, with every support order that we get. We will serve it on the employer within 15 days of every entry of a support order, or when the employee changes employment and a new employer's address is obtained. Next slide. It's effective and binding upon any existing or future employer of the non-custodial parent, may be transferred by electronic means, and it could be issued by another state's court or administrative agency, and is as binding on an employer as an order made by a California code, the California court. And the family code section that I was talking about that has that long 5,700 point something number referencing earlier, that's something that you will see right now on your slide number 20. So out-of-state orders, you would comply with them as if they were California orders. Failure to comply has the same penalties as if you would have failed to comply with a California order. But as long as you're complying with the income withholding order, employer has absolute immunity from civil liability. So as long as you're complying with an income withholding order, on its face, and you're doing what we ask you to do, you cannot be subject to any kind of liability because we got it wrong or because there was something wrong with the employee's case. As long as you're doing what we ask you to do, you have absolute immunity from liability. For out-of-state orders to contest, the obligor has to register it in this state and challenge it in the court, and the code section for them to do that is provided below. We're providing these to you in the event one of your employee needs it, so you can provide it to them. Compliance timeframes: within 10 days of receiving an income withholding order, the employer must notify the employee and provide the employee with copy of the income withholding order and notice. And then in the packet, there's also a request for hearing regarding earning assignment, copy of the statement of the employee's rights to quash, modify, or stay service of the order, blank form with instructions for the employee to file for relief within 10 calendar days after service of the income withholding order. For those of you who are used to getting these in the hard format from us in the mail, you'll always remember it's a pretty thick packet, and it's a thick packet because there's usually 2 or 3 copies of it in there. One is for you and one is for the employee to get a packet for himself or herself. And a lot of that packet is in the event that they want to challenge anything. So usually in there would be a request for hearing regarding if they want to challenge the health insurance assignment, adding the children to the case. That form would be FL 478. That's the form number for the judicial counsel form. If they wanted to say they shouldn't have to provide health insurance for whatever reason, the cost is too high, somebody else is doing, we have the wrong person, whatever their challenges with the court. And for those types of hearings, they typically will get an expedited hearing with the court. And if they want to challenge the income withholding order itself, then you would, that should be in the packet itself. If it's not, then you can just give them the form FL 450 or tell them to Google F as in Frank, L 450, and that would be the form to request for a hearing regarding an earning withholding order. And again, those will be calendared by the court in an expedited time frame. They used to be 5 days. So normally if you filed something, you would get a court date in 2 or 3 months. With these requests for earning assignments, they have them on an expedited time frame for a hearing. Compliance timeframes: the employer must begin withholding the support amount no later than the first pay period after 10 days after receiving the income withholding order. Deduct support amount from the employee's net disposable income. That NDI is the amount. That's the formula that we're going to talk about. And we'll get used to. Deduction is not to exceed 50% of NDI, net disposable income. The NDI is basically the gross income of the employee minus mandatory deductions. Mandatory deductions generally mean the stuff that the employee has no control over, those deductions. Taxes, mandatory union dues, mandatory retirement. 401k doesn't count. So anything that's mandatory that's coming out of his wages, out of his gross income, we don't count those. Then whatever he's left with, 50% of that gets garnished and sent to us. Even if the order exceeds it, then you would just take up to 50% and send it to us. The next slide, compliance timeframes continued. The employer must remit the payment to the state disbursement unit within 7 working days of the employee's pay date until served with a notice modifying amount to be withheld or terminating the order. The code section for that issue is there also. Sitting on payments is never a good thing. It's almost as bad as not sending it in at all. The obligor, your employee gets dinged because if they don't come in timely, then it shows as if they've missed 1 month of payment. And then for that month, they get dinged for interest. And then it could also trigger their license being suspended because they missed a month of payment. So it's really important for these payments to come in timely. And it's also obviously bad for the obligee because then they're relying on this money to come in for the children. So it's really important for these funds to be sent in a timely fashion. Employer responsibilities. We're on slide 25, I believe. Provide relevant employment and income information. If we ask for verification of employment, you're obligated to give us this information: full name of employee, last known residence, address of employee, date of birth, social security number. Yes, even if we want social security number, the employer has to give it to us. Those code sections cited below in your PowerPoint actually gives us the authority to ask you for that, and you're mandated to do it. Dates of employment, past and present earnings, availability of health insurance coverage. So all of those things are things that we can ask you to provide, and you do have to provide to us if we ask for it. And these are forms that we sometimes send out. Slide number 26, wage and insurance verification form. A lot of times we send these out in lieu of a subpoena. They're easier to fill out, and some of you already received these forms from us. We request information concerning the employee. You sign it under penalty of perjury, and we use them as evidence in court. And then also there's another form that we sometimes use. That one tells us the next payment due of the employer's address, last known residence address, employee's last known telephone number. That's a little bit more helpful to us if we are looking for an employee and we're trying to find them. So any help from you employers is quite helpful to us. So what is it that employers cannot do or shall not do? Employers shall not do the following based on the existence of an income withholding order. You cannot discriminate on them because there's an income withholding order. You can't refuse to hire, you can't discriminate, discipline, terminate just because there's an income withholding order, or if there is a health insurance assignment order. So if we're telling you, hey, even if it before open enrollment, you're to add these kids to his insurance, you can't discipline them, you can't terminate them, you can't discriminate on them based on those assignment orders from the local child support agency. And those are under labor code and family code sections. And there's more code sections, but those are two of them that tell you it's an absolute no discriminating. Orders, priority of withholding. So when the support is collected and comes in, child support order generally comes in first, bankruptcy order, next, federal administrative garnishment, federal tax levy, student loans, student tax levy, local tax levy, creditor garnishment, employer deductions. Priority of pays, as far as stuff from a family court goes, when child support, anything that comes from the local child support agency, if we're collecting, child support always gets paid first, spousal support gets paid second, health insurance gets paid third, and then arrears for child support get paid next, and then arrears for spousal support gets paid last. So that's our priority of pay works. And there's a family code section, and that's 4011, that in California that says child support gets paid before all other creditors. So if there's a dispute, we generally win because of that code section that says the child gets his or her support before any other creditor gets access to a mom or dad's money. Again, applying the withholding, current child family support, medical support if it's on the income withholding order, health insurance premium, current spousal support, then arrears for child family support, and then spousal support arrears. So the family support thing, what that is sometimes the court don't delineate what is child support, what is spousal support. They'll just make a family support order. It's not the preferred way of doing things. You might see that more out of state orders. California doesn't really like doing it that way. They usually like to delineate between child support and spousal support, so we know what is what. Each thing is treated differently. Each thing has a different priority. For collection purposes, we internally treat them differently with the local child support agencies. But sometimes you will see family support is ordered at that amount. So that's why you see that distinction of current child support / family support. So if it's family support, then it gets the same priority as child support because child support is lumped in with family. But it's unusual. You're not going to see it too much, hopefully. Remitting payments provide the following information for each employee: name as it appears on the notice to withhold, social security number, legal date of collection, case or court order number. Now you can remit the payments for multiple employees into one check. You can send us one check for all of them, but you do need to send us an itemized accounting stating how much of it is for each employee, so we can attribute each payment accordingly, so we know who gets credit for what. And that's, of course, all of it's going to the state disbursement unit. Again, in calculating net disposable income, NDI, mandatory deductions, state and federal taxes, state disability insurance, etc. This stuff you have no control over it coming out of your checks, mandatory union dues, mandatory retirement. So it does not include 401k because you choose how much you're putting into 401k. Does not include other voluntary deductions such as advances because you get to choose how much you're doing that. So once you take those costs out, that is the net disposable income available, and that's how you calculate the 50% subject to garnishment. And you're also, once we start talking about if the cost of health insurance is reasonable, that NDI is going to come in, may come into play also, but we'll discuss that separately. Now, what are earnings? Earnings are basically pretty broad. Family Code Section 5206 defines earnings as anything that is a remuneration for services. So some people say, you know, I'm not an employee, so it's not subject to garnishment. Wrong. If somebody's doing something for a company and they're getting money for it, it's subject to garnishment. Under the code, you're defined as an employer and they are defined as an employee, and their earnings they have earnings and they're subject to an income withholding order. So it doesn't matter whether they're getting a salary, they're getting bonuses, dividends, royalties, commissions, whatever they're getting. If they're getting money, they're getting anything of value for services rendered, that's subject to an income withholding order, and you have to comply with it. There's no way around it. Employers who fail to withhold, penalties for non-compliance. Employers who fail to withhold and forward support are liable to DCSS for the amount of support not withheld, forwarded, or paid, including interest. They are liable to employees for amounts withheld and not forwarded. Failure to comply is punishable by contempt. Employer can be sued for conversion. Employer can be charged criminally for theft or embezzlement. So sometimes with employers, the problems that we're having can fall into a couple of categories. One of them is that the employer is, for whatever reason, not complying with the income withholding order. In situations like that, most of our experience has been that they are covering for the employee. They are either friends of the employee, family of the employee, and they just want to cover for the employee. It's a bad idea, because then if the money has not come in, then we will go after that employer for those months of child support that were not paid. And even if by that point the employee no longer works for that employer, all those months where child support should have come in, the employer is liable for it. And the employer might end up paying the employee's child support, even though the employee ended up getting paid in full for all those months and is no longer working there. So it's not a good idea. Sometimes the employer just doesn't think it's fair. It thinks it's too much. It's just, those are not stuff that the employer can get involved in. The employer just needs to refer him to court or her and tell him to go litigate it. But the employer has to comply with the child support orders. Now, we have some rare situations where the employee will come in and show us their pay stubs and say, look at this, they have been garnishing my wages for the past 2 years. And we look at our system and we see that not a dime was sent to us in the last 2 years. So that could be one of two things, that the money was either applied to the wrong account, rarely, or it could be just basically good old embezzlement, theft. And in those situations, the tort civil lawsuit for that would be conversion, where the employee would sue the employer for conversion. We've had those cases in the office, and our office can, of course, file contempt charges against the employer also. And depending on the amount of money involved, we could also refer that to the district attorney's office for embezzlement and for felony charges as well. But so it's really not worth it. We really need your help on collecting these support orders. So it's best to just comply with the orders. Electronic fund transfer, there's this code section that authorizes us to do this. Can we work out a better payment plan? These are unfortunately questions that shouldn't be any of your concern. You can have your employee call our office with those questions, and we can help he or she with those questions. But those are not questions that we would be answering if the employer calls. Our cases are confidential. Employers can only be given information to comply with the income withholding order, and our office can only discuss case as it relates to employers' ability and our obligation to process the income withholding order. Encourage your employees to contact us directly. We want to help them. Thank you, and we appreciate your help.
Thank you, Herbad, for the IWO requirements. Next, we will have Angela Jones with EIWO. Angela?
Hello, my name is Angela Jones, and I'm the Employer Outreach Coordinator at California Child Support Services. I just wanted to start off by saying thank you for your critical role that each of you play in sustaining the child support program. Employers are one of the department's most valuable partners, and I hope that this virtual employer workshop is providing you with a better understanding of your value to the child support program. So first, I wanted to get started with the Electronic Income Withholding Order, or EIWO process. In previous workshops, employers have shared with me that since they have enrolled in the Electronic Income Withholding Order process, it has made processing the income withholding order so much easier. It has saved employers time and resources, and the Electronic Income Withholding Order has pushed them to become paperless in other aspects of their company because it has streamlined the Electronic Income Withholding Order process. So in this section, I'm going to go over how to register for the Electronic Income Withholding Order process, as well as the different options that are available. Then we will take a look at the different acknowledgements that you'll receive with the Electronic Income Withholding Order. And lastly, I'll share some resources that are available to you to help ease the process and provide some additional information. So what is EIWO? EIWO will allow employers to notify the child support agencies if your employee has been terminated, or if your employee is going to be receiving a bonus or a lump sum payment. And employers will also have the ability to acknowledge each of those income withholding orders, or also reject the income withholding order. So some of the benefits of EIWO, as employers have already shared with me, it has saved them time, money, and resources. And the child support payment will get to that family sooner because you're receiving that income withholding order electronically. Also, you only have to enroll in the electronic income withholding order process one time. And if you receive income withholding orders from multiple states, you'll then begin receiving all of those income withholding orders electronically. This will help increase the accuracy and reliability of the data, and there are no costs to employers when you enroll. The registration includes an agreement to process electronic income withholding orders. To register, the employer will accept the agreement and complete the Federal Employer Identification Number spreadsheet. The diagram illustrated here, it illustrates the Federal Office of Child Support Enforcement's Electronic Income Withholding Order, or EIWO process. This will be extremely helpful for your IT personnel, as this shows how the electronic income withholding order is sent to the employers from the child support agencies and then batched for each employer. Each batch will be sent to each employer, and then the employer will be able to respond to the acknowledgements, and then the batches are sent back to the respective states. Please share this diagram with your IT personnel. There are two options for employers to choose to implement. First, the system interface. It does require employers' IT resources for programming, and this is the best option for employers that receive a high volume of income withholding orders. The second is the no programming option. When enrolled in the no programming option, employers will be provided with a PDF copy of the income withholding order, and this option is most optimal for employers that have a low volume of income withholding orders, but some of the benefits of this option are a simple implementation. For employers looking to have the system option, the estimated time is about 3 to 5 months of IT resources. This is another helpful slide to share with your IT personnel. The no programming option provides employers with 2 choices to meet their needs. Option 1, the employer will receive the income withholding order as a PDF, and the acknowledgement is sent to the employer using a PDF. This option is optimal for large employers that have about 600 or more employees. The second no programming option is best suited for the small or medium-sized employers. Option 2 will still allow employers to receive the income withholding order as a PDF, but the acknowledgement is sent to the employer using Excel. The sample shown here is the PDF acknowledgement. The top portion of the income withholding acknowledgement will state if this is for an original income withholding order, an amended income withholding order, a one-time lump sum payment income withholding order, or a termination of the income withholding order. Each PDF acknowledgement will include your employee's case identifier, your employee's last name, first name, and your employee's middle name and social security number, as well as your company's federal employer identification number. The income withholding order disposition status, this is where you can accept or reject that income withholding order with the selected disposition reason code. The second sample shown here is of the Excel acknowledgement. Column B will include the type of income withholding order, whether it's an original income withholding order, an amended income withholding order, a one-time lump sum payment income withholding order, or the termination of the income withholding order. Each Excel acknowledgement will include your employee's case identifier, your employee's first name, last name, middle name, and social security number, as well as your company's federal employer identification number. Column K on the Excel acknowledgement, this is where you will accept or reject the income withholding order and include the disposition reason code in column L. This is a sample of the employer-initiated acknowledgement. This form is used for the employer to report a one-time lump sum payment or termination of employment. If the employer is reporting a one-time lump sum payment, provide the following information: lump sum date, lump sum amount, and the lump sum type. If the employer is reporting a termination of employment, provide the following information: the termination date, the employee's last known phone number and last known home address, the date of the final payment that is being remitted to the state disbursement unit, and also that final payment amount. And then also include the new employer's name and address. This is going to be very helpful information for the child support agency. Each day, the child support agency will receive an email that includes the processing summary. On the right-hand side of this slide, this is a sample of the file that will be sent to the employer daily. When preparing for the electronic income withholding order, this slide includes the types of servers and Adobe that is required. Please provide this slide to your IT personnel. The next steps in preparing for the electronic income withholding order include completing the profile form on the Federal Office of Child Support Enforcement, as well as the Federal Employer Identification Number spreadsheet, followed by setting up connectivity. Then the Federal Office of Child Support Enforcement will conduct a test, and then the employer will begin receiving the income withholding orders electronically. The electronic income withholding order resource provided here has some additional helpful information regarding the electronic income withholding order process and the options on the Federal Office of Child Support Enforcement's public website. I provided the EIWO team's email address at the bottom of this slide. When you're ready to enroll, please send an email to the eIWO team and they will be able to send test files and walk you through the whole process until your go live date. So once again, I wanted to thank you for everything that you do to support the child support program. Once again, my name is Angela Jones, and I am the Employer Outreach Coordinator with California Child Support Services. Now I'm going to turn it back over to Letitia. Thank you.
Angela, that was some great information on EIWO. Next up, we have Janet C. with Bonus Lump Sum IWO. Janet?
Hi, everyone. Welcome. My name is Janet Castorella. I'm a Senior Child Support Specialist from Kern County Child Support. I would like to start off by saying thank you for joining us today. We hope that you all benefit from the information that will be presented. I will be going over bonus lump sum income withholding orders and how you, as the employer, can report any bonuses or lump sum payments. Let's get started. First, what is a lump sum payment? A bonus lump sum payment made to an employee is considered income and can be garnished to collect past due child support, also known as arrears. One-time payment made to an employee from their vacation payouts, cash awards, or bonuses. What is considered a lump sum payment? It could be a severance, vacation payouts, insurance settlements, retirement incentives, stock options, lottery winnings, commission, awards, payments from verdicts, workers' compensation, retroactive pay increases, and sign-on bonuses. Per California Family Code Section 17512, all employers served with an income withholding order are required by California to report all earnings as defined by Family Code Section 5206. This means employers are required to report bonus lump sum income. You might ask yourself, how do I go about reporting bonus and lump sum? Well, employers are encouraged to report any bonus or lump sum payment prior to payout by contacting the Department of Child Support Services. You could do that by fax, email, electronic income withholding order, or USPS. If you choose to do it by phone or email, the phone number is 916-464-6640. The email address is lumpsumresponseteam@dcss.ca.gov. Just remember, please contact us prior to the payout. You could also visit the Federal Office of Child Support Enforcement website, and the website is listed below. The maximum withholding is 50% of the net disposable earning under California Code of Civil Procedure Section 706.052A. Did you know that payments to an independent contractor are subject to the maximum 50% net disposable earnings withholding limit? If you didn't, now you do. Now, what are the other ways to report? We have the electronic income withholding order federal webpage. You can enroll at the federal website listed below. We also have the California Services team at the following website for a brief demonstration. After the demonstration, employers can register to use lump sum reporting in the website listed below. Where would I find the state's reporting requirements, you may ask? Well, employers may find more information about each state's requirements on the State Lump Sum Requirements Matrix. Employers can quickly report upcoming lump sum payments to employees using the online bonus lump sum application on the Child Support Portal. For the state of California, you could visit the Office of Child Support Enforcement at the website listed here, and we do have a contact person. Her name is Jeanette Ramuri, and her phone number is 916-464-6640. Her fax number is 916-636-2476. And the email address is lumpsumresponseteam@dcss.ca.gov. If you'd like to mail your request, please do so at Department of Child Support Services, MS 8-300, P.O. Box 419064, Rancho Cordova, California, 95741, 9064. If you have to express your request, you can use the address listed below, 1150 International Drive, MS 300, Rancho Cordova, California, 95670. I'd like to say thank you. This completes my presentation. Hope you all continue enjoying the rest of this workshop. Don't forget, if you have any questions, you can add them to the comments and they will be answered at the end of the presentation. Thank you, and again, have a great day.
Welcome back. Okay, now we will have a 15-minute intermission. Go grab a cup of coffee, a snack, or a drink of water. Please review the flyers during this intermission as well with different events and information. We also want you to know this is Child Support Awareness Month, so celebrate with us. So go ahead and take a break, and we will see you soon. Welcome back. I hope you got your refreshments, you had a drink of water, a cup of coffee. Now we're gonna keep this moving along. Next, we have Guillermo Fernandez with NMSN. Guillermo?
Hi, good morning. My name is Guillermo Fernandez. I'm from Imperial County, and I'm part of the Department of Child Support Services here for our county. My position is Administrative Services Manager, and today I'm going to be speaking a little bit about the National Medical Support Notice. Before we start with our presentation, I just want to acknowledge and thank you all employers for their support and due diligence. Without them, we wouldn't be able to continue providing health coverage insurance or medical support to our California children and families. And for that, I thank you and appreciate your assistance. As you know, the National Medical Support Notice is a two-part notice that is sent to employers by a local child support agency. Its purpose is to ensure that children receive healthcare coverage when it's available and part of a child support order. Employers and health plan administrators are required to complete and comply with the National Medical Support Notice and health insurance information, which is available online. What are the legal obligations? Current state laws requires that health care coverage be provided under a medical support order, even if a child is born between unmarried parents, is not claimed as a dependent for tax purposes, and does not reside with the parent or in the insurance services area. All local child support agencies in California are required to include provisions of healthcare coverage in their child support guidelines. And the child support agency is required to pursue private healthcare coverage when such coverage is available through a non-custodial parent's employer at a reasonable cost. Also, all local child support agencies, when providing enforcement services, they need to include a provision for healthcare coverage. What is medical support? It's a form of child support that requires one or both parents to provide healthcare coverage under a parent's policy or cash medical support, provide health insurance if available through an employer, pay premiums for private healthcare coverage, or reimburse a parent for all or a portion of the cost of health insurance. Also, it's court-order dependent health insurance coverage and paid additional amounts to cover a portion of outgoing medical bills or as a reimbursement of uninsured medical costs. What constitutes health insurance? It's medical, dental, and vision. Those are the three topics or elements that constitute health insurance. It can be provided on separate policies. What constitutes as health insurance? It can be medical, dental, or vision. It can be a single plan, or a combined or separate policies or plans. Enrollment. The National Medical Support Notice is a qualified child support order. If health coverage is available, the employer is required to enroll the child or children as instructed in the notice. However, the employer must adhere to limitations imposed on withholdings as mandated by withholdings laws of the state where the employee is principally employed. One of the elements required for group health insurance plans are if your company maintains or contributes to plans providing dependent or family care coverage, if your employee is among a class of employees that is eligible for family health coverage after the waiting or provisionary period has been satisfied, and if coverage is available at a reasonable cost. What are the recent updates in California laws regarding reasonable cost and accessibility? Cost is presumed to be reasonable in California if the difference between self-only and family coverage does not exceed 5% of the employee's gross income. Reasonable cost will be determined by the local child support agency. Reasonable cost. let's remember that the burden of proof is on the employee to dispute a reasonable cost of health insurance. If an employee believes that health insurance is not being provided at a reasonable cost, it's up to him to object and to make it of the knowledge of the suing local child support agency as instructed in the notice that he or she received. In California, the local child support agency will use the following equation to calculate what is reasonable cost. For example, if family coverage is in the amount of $500 per month and self-only coverage is for $300 per month, the difference of $200 cannot exceed 5% of the non-custodial parent's gross income. If we have an employee that contests the enrollment for health insurance coverage, it is the obligation of the employer to continue providing healthcare coverage until a determination has been made by the local child support agency or the courts. What are some of the employer responsibilities? The employer shall allow the employee to enroll their dependent without regard to open enrollment restrictions, deduct costs of health insurance coverage in addition to the child support amount, and provide coverage to the employee's children if the employee declines his or her own personal health coverage. Provide the local child support agency with a 30-day notice within 30 days to employee's social security number and home address, name of the insurance company, policy number, and name of the person covered. Notify the local child support agency when there's a lapse in coverage, date the coverage ended, the reason for lapse, and when coverage is expected to resume. What are some of the employer's responsibility? The employer shall not deny enrollment because the child was not claimed as a dependent on the employee's tax return, does not reside with the employee, or does not live within the service area, or if it's a child born out of wedlock. Refuse to hire, discriminate, and terminate coverage for a child unless health insurance coverage has been eliminated for all employees and receive evidence that the order has terminated from the local child support agency or a California court. The National Medical Support Notice. At the beginning of the presentation, I mentioned that the National Medical Support Notice is a two-part notice that it's sent to employers by a local child support agency. Part A of the National Medical Support Notice consists that if the consists to determine if the employee is eligible for dependent healthcare coverage. If the employer determines the employee is eligible for healthcare coverage, the employer retains Part A of the notice and forwards Parts B to the plan administrator. Part B of the medical support notice, it's prepared by the administrator, and once the dependent is enrolled and the application is complete, the plan administrator notifies the local child support agency and the employer so healthcare coverage premium deductions, if required, can begin. The plan administrator is the person or the entity that enrolls the minor or the dependents in the health coverage plan. The National Medical Support Notice for timeframes. Within 10 business days, the employer must notify the employee and provide him or her with the following forms: copy of the National Medical Support Notice, Part A statement of obligor's rights and procedures regarding the National Medical Support Notice, the information sheet, which is Form FL 478, and request and notice of hearing. Within the 20 business day, the employer must enroll the employee's children to a healthcare plan and return the health insurance information to the local child support agency. Within 40 business days, the employer must provide the local child support agency with the description of the coverage available and any forms required to activate the coverage, termination, and lapse in coverage, if applicable. Within the 10 business day, the employer must notify the local child support agency office of any lapse of coverage. And within 20 business day, notify the local child support agency of termination of benefits or termination of employment by returning the termination of benefits employment notice, DCSS 1441. What are some of the points to consider? When the employee's dependent have been enrolled in your group health insurance plan, the local child support agency is required to notify the custodial parent in writing. One of the points to consider here is that the local child support agency will not be providing the information provided by the employer to the custodial parent. The local child support agency will be providing and will be writing a letter with the information to the non-custodial parent, but it will not share the information that the document that it's been provided by the employer. Penalty for non-compliance. Failure to comply with the notice of the National Medical Support Notice, it's punishable by contempt, and an employer who willfully fails to comply with the National Medical Support Notice is liable to the custodial party for the amount incurred in healthcare costs. Some of important forms. The employer response to the National Medical Support Notice Part 8 must be completed and returned this form to notify the local child support agency if enrollment can be or cannot be completed, if the employee leaves your employment, the lapse in health coverage, and if there's a dispute of enrollment. The following required forms are no longer included in the mail income withholding packets and must be obtained online. Health insurance information, termination of benefits employment notice, and request for notice of hearing regarding health insurance assignment. This is basically all the information pertaining to the National Medical Support Notice. If there's any questions, I'll be here to answer all your questions that you may have by the end of the presentation. Also, you can obtain further information regarding the California Program and Policy Branch at the following phone numbers. Or you can always email at our policy.branch@dcss.ca.gov. Again, my name is Guillermo Fernandez. I want to thank you for the opportunity for providing you information regarding the National Medical Support Notice. Thank you and have a good day. Be safe and stay healthy.
Thank you, Guillermo, for all that important information. Next, we have Barbara Wall-Ocean again, reporting new hires and independent contractors. Barbara?
Thank you, Letitia. As she stated, we're now going to cover the topic of reporting new hires, rehires, and independent contractors to the Employment Development Department. Many of these documents that we will be mentioning are also located in the binder of paperwork that you received, or excuse me, the printouts of paperwork that you received. Next slide. The new employee registry, California's new hire reporting program. Now, you as employers will report your newly hired, rehired, and independent contractors to the registry. We at that time will match the employee registry reports against child support records to help locate parents in order to establish wage withholding orders or to enforce existing orders. The information is also sent to the National Directory of New Hires to locate delinquent debtors in other states. Realizing that nearly 30% of child support cases involve parents who do not live in the same state as their children. Also, just worth mentioning, it is the law. You are required by law to report all newly hired, rehired, and independent contractors to the Employment Development Department. We will go over the timeframes to do so in a moment. Next slide. What is the definition of rehire? Rehire is if an employee relationship ended and the returning individual has been separated from that same employer for 60 consecutive days, they are considered a rehired employee, at which time you have 20 days of their start date in order to report this to EDD. Now, are you required to register an employer? We get that question quite often. Employers who operate a business you can be a person or a legal entity. if you're operating your business as sole proprietor, partnership, corporations, associations and trusts, Indian tribes, public entities, state and federal, nonprofit and charitable organizations, or limited liability companies, partnerships. Additionally, you could be considered or register as an employer if you have private households where you hire somebody to do work for your house, local college clubs or local chapters of college fraternities or sororities. Next slide. Now, who must report? You must register it as an employer with the Department of, for the Employment Development Department, pardon me, if you operate a business and employ one or more employees when you pay wages in excess of $100 in a calendar quarter, or you are a household employer of one or more household workers when you pay cash wages of $750 or more in a calendar quarter. Any California business or public entity that is required to file a federal Form 1099 miscellaneous is required to register as an employer, as well as multi-state employers, employers who hire employees in more than one state. Next slide. Why is this important? It's very important in allowing us to locate parents who owe the support, allows us to increase our child support collections, reduces welfare costs, and reduces Medi-Cal costs. And again, bears repeating that it is the law. Now let's go over a little bit of the penalties if you do not report within the required timeframes. The first one, the company could receive a $490 penalty for intentionally failing to report. There could be an agreement between the employer and the employee to not report. Employers may also be charged a penalty of $24 for each failure to report the hiring or rehiring of an employee within the time required. Now, I need to emphasize that the $490 penalty is for intentionally failing to report, whereas the $24 penalty is for, say, for example, you don't report, you're like a few days late, then they have the option of charging you the $24 penalty for your failure to report. Next slide. Now, here's the timeframes that I was telling you about. When must you report? You have to report within 20 days of hiring a new rehired employee or independent contractor within the start of work date. The start of work date is the first day services were performed for wages. Paying $600 or more to an independent contractor, or even entering into a contract for $600 or more. Next slide. This is a sample of the form. Again, within the packet that you received, there is a larger copy, so you can go through that. Reporting a new hire employee is the form DE-34. You can send it to this address here, which I'm certain will be provided to you. Additionally, you can go on to the EDD website, which is edd.ca.gov, and type in DE-34 in the search feature. Now, there is also a way to do this online, which I will go over in a moment. Next slide. Reporting requirements. Now, you need to report the employer's California payroll tax account number, branch code if applicable, federal employer identification number, business name and address, contact person and phone number. You must also provide the employee's first name, middle initial, and last name, social security number, home address, and start of work date. For those of you that have corporations in other states, you have to report in more than one state. Again, you can elect to report electronically all newly hired employees to one state in which you have employees. An example, if you have branches in Arizona, Nevada, and California, you can go online and just report everything in one state. You don't have to go to each state's EDD. Now, one thing to remember that it's very important when you're reporting any of these things that when you fill out the forms, that you are consistent in your business name and addresses and everything. For example, if you fill out a form and you put on one form, you put Jane Jones Incorporated, and then on another form, you have J Jones Incorporated. This will cause a problem because you possibly be reported twice, and that's going to cause a lot more paperwork, which none of us need. You are required by law to report. Now, as far as independent contracting, this is slightly different. An independent contractor is somebody who provides services to a business or government entity. You're required to report them. Again, if you have to fill out a 1099 miscellaneous for services, you pay them $600 or more, or enter a contract for $600 or more, or the independent contractor is an individual or sole proprietorship. Again, you have that 20-day limit that you need to report them within that time frame. Now, if you're unsure if you are hiring an independent contractor, you can read the Employment Determination Guide. Now, this is also located on the EDD website, which again is edd.ca.gov, and then use the search button and type in the Employment Determination Guide, and you'll be able to find it. There's also various scenarios and fact sheets in the packet that you received. The independent contractor reporting requirements. For them, you have to report their first name, middle initial, and last name, social security number, address, start date of contract, if no contract date, whenever you pay them $600 or more, amount of contract, including cents if applicable, contract expiration date if applicable, and whether or not it's an ongoing contract, if again applicable. Now, for yourself, you need to report your fine, your California employer payroll tax account number, if applicable, social security number, service receipt, name, business name, address, and phone number. Next slide. How to report the independent contractors. This is a slightly different form than the one. And again, there's a sample in the packet that you received. Where to send the report? It is the form DE 542, or also known as DAE 542. This is the address of where you can send the hard copy of the form to. You can also locate the form on the EDD website, which is edd.ca.gov, and type in DE 542. Next slide. Now here's where I'm going to tell you how you are able to also report these online. You can submit a paper report, again by mail, as we said, or you can enroll and report online using eServices electronic filing. The website is https://eddservices.edd.ca.gov. You can also contact your local employment development department at the number provided. Now, when you go to this website, you can select eServices for Business, and the first time that you use this website, you will be required to enroll. There is no cost for using this system, and it is very secure. Thank you very much for your time and attention, and please place any questions you may have in the chat, and we will be happy to answer them. Thank you very much.
Thank you again, Barbara, for that information on reporting new hires and independent contractors. Now we will hear from Cassandra Gonzalez with updating employer information.
Hello, once again, my name is Cassandra Gonzalez, and I am a supervising child support specialist with Kern County. In this section, once again, we'll be discussing updated employer information. Next slide. Keeping our office updated, information should be updated with our office is, do you need to update your employer fax number? Has your company changed their name? Has the payroll contact person changed? Or has the payroll company you use have has changed? Do you need to update the health insurance information? Has the company moved and is there a new address? These are the types of changes and updates that are important to provide to our office. Next slide. Reasons to keep our office updated with any changes is it helps maintain accurate employer information. It prevents a duplication of forms being sent out. Sending and receiving the income withholding order or the IWO or the National Medical Support Notice, the NMSN, employment verifications to the appropriate address and individuals. It helps keep the employer and our office in compliance, and it also helps with employer timeframes and making sure that they are being met. Next slide. This slide shows the Child Support Service website, and the website is listed at the bottom. In the corner, up right-hand corner of the website, you'll see the hyperlink that says employers. You click on that website and it'll take you to the Employer Resource Center. Next slide. So this is the Employer Resource Center page. You'll see two links on this page, one on the left-hand side under Employer Quick Links. Clicking on Update Employer Information that is highlighted, that's one way to get you to the forms to update your employer information. You can also click on the link that's listed at the end of paragraph 1 to get you to the page to update your employer information. Next slide. Once you click on the link to update your employer information, it will take you here. This is the Employer Update Contact Information form. This form is where you'll provide any and all updates for your employer. It's important that you indicate the employer name, the 9-digit federal identification number. This is where you'll provide the payroll garnishment information, health benefit information, and any other information that needs to be updated with our office. At the bottom of the page, you'll see a subscribe box. If you click on this, you are able to subscribe to the DCSS Employer Update email list, which by signing up for this list, you'll receive tips, information, employer services newsletter, and helpful features for the employer. Next slide. By clicking on that subscription box, it will take you to the employer update email list. This is where you'll place your employer name, email address, and once again, clicking on the subscribe button to be able to subscribe to receive any employer events and updates. Next slide. Another link that's available on the child support website for the employer resource is the Employer Frequently Asked Questions. On this page, you'll see frequently asked questions regarding the following categories: the income withholding orders, electronic income withholding orders, making payments, the California State Disbursement Unit, payment options, reporting new hires, termination, and medical support orders. Next slide. Another website that can be used that has information for employers is the Child Support Directors Association of California website. Next slide. The website is listed on the up right-hand corner. Once you get to this page, you'll see the tabs at the top. You'll hover over the Outreach and Indication tab. That'll bring down a drop-down menu. From there, you'll click on the Employers link. Next slide. And from there, it'll take you to the page for the employers, and you'll see the employer forum. And there's a hyperlink for the employer forum webpage. You click on that webpage and it'll take you to the employer. I'm sorry, you click on that link and it'll take you to the employer's forum. The employer's forum is an event that was held that regarding questions for employers that was recorded and that is available for you to view. Next slide. So this slide has the employer information and contact office information. So you can contact our office customer service by contacting the 1-888-898-1743 and our customer contact center, which is the 1-866-901-3212. The employer contact list for the local child support offices is listed below with this hyperlink. Once again, thank you for participating in this employer workshop. We will be available after this to assist you with any additional questions you may have. Thank you.
Thank you, Cassandra, for that important information with updated employer information. Next, we have Sabrina Damasi with SDU. Sabrina.
Hi, my name is Sabrina, and I'm with the County of Riverside Department Child Support Services, and I'm a Senior Child Support Specialist. And today I'm going to be going over State Disbursement Unit, or SDU. The California State Disbursement Unit, or SDU, is a single payment processing center for employees to send child support wage withholding. The reason for their creation is to simplify the payment submission, improve accuracy of child support records, disperse speedy payments to families. Federal law does require that every U.S. state have one central location which processes all child support payments. Employers are required to direct all payments to the State Disbursement Unit. The state and county functions are centralized payment processing, collections, disbursements, fund allocations, set up electronic payments, non-4D customer service, and expert pay for employers. For you employers, you must again remit all California child support payments to SDU. It is imperative that you include the necessary employee identifications named here. We need the employee's name, social security number, CSE participant number, amount, date of withholding, and the child support enforcement or CSE case number. Again, this is extremely important. If we don't have all of this information, the state will email me, and then I would have to contact you, the employers, to get the verified information in order for it to be submitted for allocation. Again, you want to make sure that we have all of this information so that way we can avoid any kind of delay in processing the child support payments. SDU timeframes. You're going to begin the withholding within 10 days. You're going to send the amount withheld within 7 days. You're going to notify the issuing LCSA in writing within 7 days if the employee is no longer receiving payments from you, receiving disability, or is currently on leave. Payment options. If the employer has more than one employee with a child support obligation, the payments may be combined into a single check. This just means if you have 5 employees, for example, that you have to pay California State Disbursement to for child support obligation, you may submit just one check, but you also need to include a breakdown, and this is exactly what we need. So you would include the employee's name, independent contractor name, child support enforcement or CSE case number, the employee's social security number, date money was withheld or the pay date, the amount withheld for each employee. You want to include a company contact name and phone number. Employers who fail to withhold the amount as specified on an IWO may be found liable for the full amount of the support owed plus a fine. The benefits of electronic payment options. Employers are encouraged to send payments electronically. These transactions are faster, they're more accurate, and less expensive to process than the paper check. If an employer pays taxes electronically to the Franchise Tax Board or the FTB, or the Employment Development Department, EDD, then the child support payments are required to be sent to the SDU using the electronic funds transfer, the EFT. And this is in pursuant to the California Family Code 17309.5. It results in fewer errors, no lost checks, saves time and money, reduces the risk of theft and fraud, faster SDU collection, receipt, and processing, and we always want to try to go green as much as possible. Expert pay for employers. Due to regulation changes from the National ACH Clearinghouse Association, the State Disbursement Unit is required to make changes to the SDU payment portal for payments made via a bank account. Changes went into effect in January of 2020, and they slightly altered the way customers make payments via the SDU webpage, interactive voice response, e-payment link, and e-payment call center. The SDU's bank account payment option went away, and the ACH debit payments are now submitted through the Expert Pay platform. Employers are no longer able to pay ACH debits from the SDU website. If they are sending payments via UPIC, they will continue to make the payments that way. Payments will be processed through Expert Pay, then sent to DCSS Bank and to the SDU. The process can take 3 to 5 business days, and you may sign up with Expert Pay at any time. There is a one-time registration fee of $2.50. The SDU will start the registration process for the employers. It is recommended that you complete the process a week before you make that first payment, just to make sure that the validation process is completed. This here is what the Expert Pay website looks like. Okay, we're gonna have to cut there because Molly decided that she was going to say something. Okay. All right, we're gonna start again in 5, 4, 3, 2, 1. Expert Pay allows the employer to maintain employer data and facilitates the federal mandated payment of child support payments withheld from employees. Submit child support payments to the State Disbursement Unit via the internet. Save and maintain payment information for quick transactions, and creates a separate payment groups. If you have more than one facility in your state, you can create separate profiles for each facility. And if you've registered more than one bank account, you can use different bank accounts for different profiles. In order to use Expert Pay, you need to register and set up your user ID, your bank account information, and payment groups. Users will also be able to submit payments using their debit or credit card and PayPal accounts through the Expert Pay platform at cost to the remitter. The current process for using credit card via SDU website, IVR, e-payment link, the CSE link, and e-payment call center is currently 1.9%. Details on Expert Pay are found on this website here. Again, this is what the login pages look like for Expert Pay. Employer payment options are as follows. You can make a payment online by going to www.casdu.com. You can mail a check to the State Disbursement Unit at P.O. Box 989067, West Sacramento, California, 95798-1326, or you can use Expert Pay at this website. Contact information for the State Disbursement Unit is the website www.childsup.ca.gov. You can also contact them between the hours of 6 a.m. and 6 p.m. at the phone number of 866-901-3212 using option 1, or we have the fax, email, and website listed here, as well as the mailing address. Programs and services we offer and how the process works can be found on the State of California website located here. And make sure you see our video resource library and FAQs. Thank you so much for coming in today, and I hope that we were able to make it a lot easier for you to understand how the payments are submitted to the State Disbursement Unit. Thank you.
Thank you, Sabrina, for that SDU information. That was the end of our presentation. Now it's time for us to answer some of your questions you may have. Okay, so we have a couple of questions in the chat. Our first question, what do you do if an employee is terminated or no longer working? Who do you contact? Barbara will answer that question for us.
There's quite a few ways that you can report to them. What happens now, the first thing that you can do, if you remember when you received the the income and withholding order, there should be a sheet on there that says that the employee has terminated, then you can just send that to us. You can also call us at 866-901-3212, and you will be transferred to the appropriate county, and we can do that for you. Sorry, there's an echo coming in here.
Thank you, Barbara, for that answer. Question number 2.
Okay, now I can talk because hopefully my echo won't keep doing. Again, you can call the 866-901-3212. You can also email the termination notice to us at for San Bernardino County, for example, there's a child.support-mbx@hss.sbcounty.gov, but you can obtain the email address from any of the counties by calling the 866-901. You can also fax a termination notice, and then again, our fax termination for San Bernardino County is 909-799-4939. If you are in any doubt whatsoever, the best thing that I can suggest is you contact the 866-901-3212. Thank you, and I hope that answered your question.
Thank you, Barbara, for that answer. Question number 2. My company closed during the pandemic, but we are opening up again later this year. Do I need to notify the state of my closure related to employees who have a child support order? Question number 2 will be answered by Guillermo. Question number 2 will be answered by Angela. Angela?
Hi, good morning. Thank you for your question. Yes, notice has to be given to state DCSS and also the county that it's been handling your case. You can always contact our phone line, which is 866-901-3212, and you can be request to be transferred to the county that I was handling the case and that you were making your child support payments. But you can contact either the state or you can contact your local child support agency.
Thank you, Guillermo, for that answer. Next, we have, what is the number I can contact if I have follow-up questions? Angela?
Okay, the next question is there a number I can contact if I have a follow-up question? Yes, if you have any follow-up questions regarding the...
Will be answered by Angela.
Sorry. If you have any questions regarding any of the withholding orders or the medical support notice, you can always contact the main number, the 866-901-3212, or or contact the DCSS Employer Customer Service number, which is 1-888-898-1743.
Thank you. Angela, would you like to add to question number 3? You can also add to question number 2 as well. Thank you for joining us today. I hope you got a lot of good information from this presentation today. Remember, you can always leave comments on any of the county's websites. And let me remind you of all the counties involved today. We have Riverside County, San Bernardino County, Kern County, Imperial County, and the state DCSS. Remember, any questions you may have, please feel free to put them in the chat. Once again, thank you to all employers. We hope you receive the information you needed when dealing with our department and its forms. Once again, I'm Letitia Stevenson. Remember, this is Child Support Awareness Month. I'll see you next year. Bye.